Wisconsin Law School, and Dean is always one of my guest lecturers. This year when I got the course evaluations back, written down at the bottom in capital letters in red pen was, "More Dean, please, more Dean."
Well, I'm going to start with a confession this afternoon. I can't teach, and I'm going to push it one step further. I don't think anyone else can teach either. Just as an article of faith, I don't believe we can teach. I'm here because I believe you can learn. And I think there's a fundamental difference in those two things. But if you think back, at least when I think back, I won't speak for you, when I think back at the teachers I've had, whether that's professionally or in high school or elementary school, none of them really have taught me. What they've done is inspire me to learn. Make me want to learn, make me want to be better, make me want to know more about whatever it is that excited them. So this afternoon, I'm going to try to get you to be a little bit excited about learning about evidence and thinking about evidence and using evidence. The topic, as Darrell describes it, is making and meeting objections. But fundamentally, folks, this is evidence. And let me give you a context for why you ought to find this exciting. At least it resonates with me. I'm interested, just casually and as an amateur, but I'm interested in the law and literature movement. What it is that literary texts and the process of writing tells us about interpreting legal texts or understanding law. And whether it's James Boyd White or other people who've come after him who've written about law and literature, I think one insight these folks have is that law is a language or a set of languages that allow people in a particular subculture to communicate well with one another, to understand what one another is saying. I'm not going to lecture about law and literature, but I want to propose to you that if you're going to be a trial lawyer, just as if you were going to be a biblical scholar or a scholar of the classics or a chemist, there are languages you must master. There are languages in which you must be fluent if you're going to have the audacity to call yourself a trial lawyer. You've got to master the language of speaking to jurors. You've got to master the language of speaking to clients. You've got to master the language of speaking to trial judges. Many of you will have to master the language of speaking to appellate courts, to panels of 3 or 7 or 9 on an appellate court. These are different languages. The words, the formulations you use when you're arguing in New Orleans at the United States Court of Appeals for the Fifth Circuit are different than the words you use when you're communicating with Bonnie Kitchens. Different than the words you use when you are communicating with a harried, unhappy, angry, low-functioning judge in the trial court in St. Louis, Missouri, who's got 50 cases on his morning calendar and another 50 on his afternoon calendar. These are different languages. And evidence is one language of law in which we must become fluent if we're going to call ourselves lawyers and have that mean something. You wouldn't suggest that you were an antiquities scholar unless you learned some Hebrew and learned some Aramaic and learned some Greek. You wouldn't suggest that you were fit to talk to others about the classics unless you picked up Latin and Greek. And you oughtn't suggest that you are ready to try cases in an American courtroom unless you pick up the language of evidence somewhere along the way and become a reasonably competent speaker of that language. Now, that's what gets me going. I see it as a language, as a set of conventions by which similarly educated people in a subculture can communicate well with one another. You can see it any way you want, but I want to suggest to you that becoming fluent in, or familiar with, comfortable with, if you like that better, the rules of evidence that apply in whatever jurisdiction or jurisdictions you practice is essential. It's also fairly easy, and it's fun in the end. So why is it that so many of us criminal defense lawyers are stuck on, on the most elementary understanding of evidence? Why is that? I don't know. I mean, most of us wander around the courtroom as if all we knew about evidence were the equivalent of walking around with a Lonely Planet guide in France and trying to ask, which way to the bathroom. Or trying to order a beer at a cafe in Italy or something. That's the level of fluency most of us have with evidence. I don't know why that is, but I see it week in and week out in the courtrooms of Wisconsin. And my surmise is that Wisconsin lawyers really aren't all that much dumber than lawyers in the rest of the country. So let's try to work with it today. Again, I can't teach you evidence, not in 35 minutes and not in 35 years. But I'm hoping to plant a seed that will give you reason to want to learn and to get better at evidence. And I understand, starting off, that there are people in this room who know more about evidence than I do. And there are people in here who almost surely know a whole lot less about evidence than I do. So if I'm not speaking to you directly, I apologize, but take neither offense nor too much pride if you feel like you're below or above the mean at which I'm pitching this. I want to focus on 3 specific problems, just as a way to get us thinking about making and meeting objections. First of all, the problem that we just don't object at all often when we should. That's one very basic problem, it seems to me. Second, I want to talk about hearsay. And I think the problems that defense lawyers and a lot of other lawyers, for that matter, have with the use and the misuse of hearsay. We don't know how to use it when we want it. We don't know how to keep it out when we don't, often. And finally, I want to go right to the belly of the beast, as far as I'm concerned, and talk to you about pieces of paper, business records. Pieces of paper you either want to get into evidence or keep out of evidence. My experience has been here at Macon and generally that when when the subject of business records comes up with defense lawyers, their eyes just glaze over. They have heart palpitations, or they run out of the room, or they turn ashen white. All kinds of strange things happen when you start talking about documents and their admissibility in defense lawyers. So I'm going to give it a crack here. But I want to take these in order. So first of all, why don't we object? Why so often has the cat gotten our tongues when we should be saying something? Let's work on this. Let's just start with basics here and get you guys moving. Suppose I'm a witness and I have just said something on the stand that is utterly incompatible with your theory of defense. Shockingly bad for your client. And making you feel so uncomfortable that you would, crawl under the table if you thought you could get away with it. I just said something like that. What are you going to do? See, this is usually what happens. You're going to object. Okay, and how are you going to object? Let's do it. Ready? You're going to, this is real simple. First you stand up. Stand up. You now square your shoulders. And we'll just do the basic form, okay? I object. I object. Now see if you can string those steps all together. Sit down. Ready? See how fast you can do this. Ready? Stand up. Square your shoulders. I object. Now, you're almost halfway there. Literally, truly, you're almost halfway there. Not quite halfway. Because so far what you've said won't preserve anything for review later or tell the judge much about what it is you don't like. You can sit down. But just getting on your feet, squaring your shoulders and say, I object, gets you almost halfway there, folks. So as I say, not only is this essential, but it's easy. It's essential because I don't know about you, but while I'm in confession mode, here's another one. I lose a lot of my cases. I don't win them all. Many of my clients I plead guilty. And the ones I don't, when I go to trial, lots of those cases I lose. Now you may all be better than I at trying cases, but my guess is that somewhere along the line, you're going to lose a case in this business. That may not be true if you were going to prosecutor school, but you're in defense lawyer school, and you're going to lose a case somewhere along the line. If it's a really, really bad year, you might lose 2 in a row. And when you lose, there's an outside chance that your client won't say, I think the jury was right. It's just time to take my medicine and make the best of it. There's an outside chance that somebody's going to want, an appeal, right? And, again, speaking only for myself, if I've spent a day or 3 days or 3 weeks or 3 months trying a case, and the case has to go down to Chicago to the U.S. Court of Appeals for the 7th Circuit, or it's got to go to one of the 4 districts of the Wisconsin Court of Appeals, I don't want those judges thinking I'm an idiot. I want the case to go there with something that they can review other than for plain error. And that's about objecting. Now, I told you didn't get quite halfway there by saying, I object. Well, you didn't. You didn't give any grounds for your objection. We're going to need to state some grounds for that objection to get us where we want to be. Occasionally, if it's so over the edge, just saying I object will cause the judge to sustain it, but not very often, right? So the nice thing about standing up, squaring your shoulders, saying I object, and then if you need to buy a little more time, Your Honor, is it gives you time to think about what it is that you're going to say your grounds for objection are. Because you probably can't stand up and say, you know, I object, that's just terrible. Or I object, that's really bad for my client. It's not going to go anywhere, right? So you got to have some reason that you're giving for your objection when you stand up. But this buys you a little time to do it. Now, what reason you're going to give for your objection will be terribly dependent in some ways, but only in some ways, on what judge presides in the case. Some judges don't like speaking objections. That is, they don't want you to lay out in any length or color the reasons for your objection. Some go as far as saying, all I'll allow is, you know, that you cite the rule number. Others, you know, I want a 1 or 2 word objection, and then we'll treat it in sidebar. Still, other judges are more relaxed about it. To the extent you can, I at least want to suggest that you would prefer to make your objections in plain English. Not using rule numbers, in a way that communicates to the judge the grounds of the objection, but also to the jury why this is unfair, improper, a low blow by the prosecution. All right? So, the objection might be hearsay, but another way, if you can get away with it, and you know, if this is fair game in front of your judge, another way to say that would be, Your Honor, he's just saying something he heard on the street. That's hearsay, and it denies the right to confrontation. I object. Again, you may not be able to get away with that sort of a speaking objection in front of a jury. There may be reasons you don't want to do that. But as a starting point, I at least like the idea of using plain English in making an objection. A reason I like that ties into why I'm objecting. I want to at least suggest to you that you're not objecting every time something is simply inadmissible. Mere inadmissibility is not a good reason for an objection, ordinarily. If I sound like I'm contradicting my point that defense lawyers object too little, I'm not. I'm simply saying there is an opposite extreme as well. And objecting to everything that is merely inadmissible usually is not effective advocacy. It's a demonstration that you have an encyclopedic knowledge of the rules of evidence, perhaps, but it's not persuasive with a jury. It's irritating and unpersuasive to a judge. So, mere inadmissibility is not ordinarily why we would object. We object because something is inadmissible and it's incompatible with our theory of defense. It's inconsistent with our entire theory or with the theme that we're using here. If you over-condition yourself to object to the merely inadmissible, you'll end up objecting to some stuff that turns out to be pretty helpful. The prosecution may open a door with inadmissible evidence that you're happy to walk through. So the inadmissibility of the testimony, the exhibit, whatever it is, yes, is a condition of the objection, but it's not sufficient, at least in my view. What's coming in also has to be damaging to our theory of defense. And if it's damaging, if it's incompatible with our theory of defense, then you see why I prefer the plain English objection. Because it allows me, in effect, to restate or reinforce my theory of defense, or part of it. To sort of react to it immediately in a way that will be communicative to a jury. Now, if you can't, wherever you're practicing, you're in front of some uptight federal judge in somewhere who fancies herself a scholar of the rules of evidence and a stickler for procedural and protocol, then you do the best you can. If all she's going to allow you to say is 404A and 403, Your Honor, or hearsay confrontation, then that's what you do. Once we've articulated a ground for objection and done it in language acceptable to the judge before whom you're practicing, now we want to look to aggregate grounds for objection if at all possible. This is something that I've failed at times. This is something that I see other lawyers fail at frequently. Looking to aggregate the objections and specifically to constitutionalize, ugly word, but to add constitutional grounds for any objection we possibly can. So, if the objection is hearsay, each and every time there is also a confrontation problem, right? Each and every time with hearsay. Because the law of confrontation is going through a relatively rapid change now, whether you mark it back to Lilly against Virginia or Crawford against Washington, or whenever you think that the current resurgence of the Sixth Amendment right to confrontation began, because we're in the midst of that right now, we've got to be careful, I think, in making hearsay objections to distinguish hearsay as a matter of evidentiary rule from the right to confrontation. Now, there will always be a confrontation problem if there's a hearsay problem, but sometimes there's still a hearsay problem even when there's not a confrontation problem. Okay? For example, let's say under the current framework of Crawford, the out-of-court statement being offered by the prosecution is non-testimonial. It's, the judge rules, and let's just assume correctly, that it's non-testimonial. It was something said spontaneously, something the declarant did not expect to be repeated in court or in a legal proceeding. It's simply a non-testimonial statement. You're not, under Crawford, going to have a Sixth Amendment objection to that statement coming in. But you very well may have a hearsay objection, all the same. You with me? So we don't want to conflate hearsay and confrontation. And we don't want to leave either out. It's essential, folks, really. I mean, it is essential for those of you, for example, who try death penalty cases in state courts. It is essential to add constitutional grounds to your state law evidentiary objections. Because when this case gets to federal court on habeas, if you have not argued the Sixth Amendment right to confrontation or some other constitutional basis in addition to the state law evidentiary basis for your objection, there's nothing for the federal court to look at least, in the trial. Now, It's of course not just hearsay and confrontation that can be paired together. If it's hearsay we're trying to offer, and we're being prevented from doing that by the invocation of some state rule against hearsay, we've got the Fifth Amendment due process right to be heard. We've got the Sixth Amendment right to a fair trial. We've got the Fifth and Sixth Amendment rights to present a complete defense. And we've got some Supreme Court precedent to support us. Now, that Supreme Court precedent is aging gracefully, okay? Chambers against Mississippi, cases before that. We have to go back a ways. But the court has not disavowed the Fifth Amendment right to be heard as a matter of due process, the Sixth Amendment right to a fair trial, the Fifth and Sixth Amendment rights to present a complete defense. And Chambers stands, at least for the proposition, that when that fundamental right to present a defense bumps up against a state evidentiary rule that appears arbitrary, the state rule's got to give. So if you're trying to push evidence in, you've got the Fifth and Sixth Amendments to cite and to rely upon in getting around the state evidentiary rule if you can. And if you see this problem coming, I'm going to run into trouble offering some aspect of my defense because of a state evidentiary rule, this is a good time to crack the books, to go back and look at Chambers, or to bring it up. Within the last 21 years or so, there was Rock against Arkansas, which touches on the same topic. But you're going to want to refresh yourself and be ready to go in either arguing that to the judge, or better yet, having a trial brief, or advancing it, fronting it with a motion to eliminate. Okay, let's go to hearsay. Hearsay, again, is not that complicated a concept. Anybody tell me off the top of their head what definitionally hearsay is? An out-of-court statement offered for its truth. I think that's what I heard from just about everybody, actually. All right? Out-of-court statement offered for its truth. That's not all that complex. Okay? And if we want to use hearsay evidence, we focus on, first of all, not for its truth. Because if I'm offering for this for some purpose other than to prove the truth of the matter asserted, it's definitionally not hearsay. Now, I may get a limiting instruction on that, but my bet is that most jurors haven't the foggiest idea what a judge is trying to tell them when he says, you may consider this for the fact that it was said, but not for its truth. Huh? No, I'll take that. I'll take that. If that's the limitation on getting in the helpful out-of-court statement, I'll take that 9 times out of 10. But beyond that, folks, look, we got 24 exceptions when the unavailability of the declarant is immaterial. We got another 5 when the declarant is unavailable. We've got residual exceptions for both. We've got all kinds of things we can argue when we want hearsay in. The problem is you have to have thought this out in advance. Most of us aren't good enough to know that, 803.17 is for learned treatises, if in fact 803.17 17 is for minor treatises. Or, you know, most of us can't remember on the fly how exactly to handle a document as past recollection recorded. We have to have thought this out. And if it's going to give our judge trouble, motion eliminate. Again, defense lawyers don't like to write as a rule. You can imagine what I think about that. Not much, but this is the reality. Most of us don't like to write, and to be perfectly fair, especially if you're in the state public defender office, or you've got a very high volume private practice, you don't have a lot of time to write it. But if this case is going to trial, and if it's got evidentiary issues, hearsay issues that you know are going to pop up, even if you don't write something, at least please think it through and know what rule you're relying on in offering the evidence you want to offer. Bear in mind definitional non-hearsay as well. Prior sworn statements of the witness, non-hearsay. Statements of identification of a person made by that witness, defined out of hearsay, under 801 if you're using the federal rules. Statements of party opponents, including statements of agents of the party opponent within the scope of that person's agency. Does this include cops? Does this include law enforcement agents? It can. It can, if they are saying things within the scope of their agency. As an employee of your party opponent, the state, this may very well include out-of-court statements by law enforcement officers. Now, the case law goes both ways on that, and if what you're looking for is to elicit a hearsay statement of a cop, again, you're going to have to be armed with a case, or at least an argument under 801D. And I think when hearsay is being used against us, it's really the same rules. We have to be anticipating this. We'll see it often in discovery. We'll see the statement that potentially is troublesome. We have to anticipate it and be ready to argue why it does not come within an exception. In this regard, this, the apparent codification of evidence that has happened since 1975, almost exclusively since 1975 in this country, the idea that evidence rules are all written down somewhere with numbers, it's illusory. The law of evidence is now and always has been primarily decisional. It's primarily case law. If you're in a state that has codified rules of evidence, as most do now, it's just the starting point. All right? It's just the starting point. It gives you access to the cases you'll read, or it gives you a place to look in a treatise. But it's illusory to think that what you need to know about evidence is in the code. I had a case in Alabama a number of years ago and was surprised to find that in Alabama, all the lawyers and all the judges seemed to believe that it was a hearsay exception if a statement was made in the presence of the defendant. Mm-hmm. Prosecutor would say, well, Your Honor, that statement was made in the presence of the defendant. Objection overruled. What do you mean it was made? So what? So what? Made in the presence of the defendant. Well, I made the mistake of assuming that the rules of evidence that mattered all were codified. And indeed, what I had run into was an old and sort of resolutely held belief among lawyers, not just in Alabama. I think Tennessee has the same sort of tradition, and probably other states do, that you develop this sort of bastardization of the adoptive admission. That somehow if the defendant was there and heard it, he's now adopted that statement, and it's a statement in effect of the defendant. Well, unwrapping that took, getting into evidence treatises on Alabama evidence, cases, to sort of get at how did that belief arise among lawyers, and what could be said about demonstrating the inadmissibility of a statement that happened to have been made in the presence of the defendant. All right. Quick mention of a couple of other hearsay points. One, if you're in a jurisdiction that uses the federal rules of evidence or something close to that, keep in mind 805, which is the rule that says for each level of hearsay there must be an applicable exception. So the fact that it's double or triple hearsay doesn't mean this is inadmissible. It just means the proponent has to show that each level of hearsay fits within a recognized exception to the rule excluding hearsay. If you're the proponent, it's good to know about Rule 805 and be prepared to make that showing. If you're the opponent and you've got double hearsay, it's good to be able to cite that rule and say, yeah, one level of this may come in as an excited utterance, but the second level, repeating that outside the courtroom, does not. And even more fun, before we leave hearsay, 806. 806 says, look, if a hearsay statement is admitted, you get to impeach the declarant just as if he or she had testified in trial. Anything you could do to impeach a live witness, prior inconsistent statements, character for untruthfulness, specific instances of misconduct, if probative of truthfulness, anything you could do with a live witness, you can do under 806 with a hearsay declarant. That's fun, or it can be fun. When the prosecution is trying to be too cute on admitting hearsay from somebody they're not calling, and now we've opened that person up to impeachment. All right? Business records, and then I'm done. Anybody know the federal rule of evidence that says that all pieces of paper offered by the prosecution are admissible? You do? What's that? 101. 101? A1, I see. All right. Well, we act like there is a rule. We usually do. We just sit there and take it. Oh, in come those horrible telephone records. In comes the utility bill. In comes whatever. Piece of paper against us. Right? Maybe it should come in and maybe it shouldn't come in under 8036. But I think we want to become better than we are at both offering business records smoothly and capably when we need them, and at least slowing down the receipt of pieces of paper when offered by the other side if they hurt us. If they don't hurt us, folks, we're not objecting. Mere inadmissibility, again, is not reason to object. If the prosecution wants to offer 5,000 pieces of paper and they don't hurt us, fine. Let them talk to the jury about 5,000 pieces of paper. Or send the jury, rummaging through boxes of documents. I don't care if they don't hurt me. If they do, we've got to be ready to explain to a judge why these are not admissible. All right, I'm going to flip it around a little bit in the order that the rule gives you for foundation. But I'm going to talk about it in terms that makes more sense at trial. First of all, do we have a qualified witness? Doesn't have to be a custodian. The rule talks about a qualified witness. If I'm a proponent of the records, I probably want to lay out the qualifications of my witness, almost as if she's an expert. How long has she worked for this company? What does she do at the company? Has she had different positions within the company? Is she familiar with the records that the company produces? How about this particular invoice or report or tabulation? Is she familiar with that? How is she familiar with that? What does the company do with those? You know, if I'm the proponent of this document, I want to bring this out in plain English and in an interesting fashion, if I can. Credit my witness and credit the documents by crediting the witness. And then once I've established there's a qualified witness, this is really pretty much common sense. First, I'm going to have to show that the record is approximately contemporaneous. It was made at about the time of the events recorded in it. So it's made when recollection is fresh. All right? There's nothing mysterious about that. You would reason your way to that if you were thinking about what makes a document reliable. Second, related. It was made by a person with knowledge or was prepared on the basis of information from a person with knowledge of the matter set forth. Again, common sense reliability. Right? Somebody pretty close to the authorship of this document should know the facts, conclusions, whatever asserted in the document. Next, was it made and kept, both made and kept, in the regular course of that business, which itself, business, should be a regularly conducted activity. So in other words, business is broadly defined. A police department is a business. Also happens to be a public agency. We could offer police reports as public records, but if we want to offer them as business records, a police department, for example, is a regularly conducted activity. So made and kept in the regular course of that regularly conducted activity. Why are those important? What it's telling us, if you go below this into 500 years of case law on the shop book rule, what it's telling us is that somebody's got a business duty to record accurately, and there's business reliance. The business itself counts on the accuracy of the document in sending its bills or keeping its books or deciding how to deploy its resources or whatever it is. There's some business reliance on the document. That's why they keep it, and they're regular about doing it. That's why they make it, because there's a duty to make it and they rely on it. And that's it. That's business records, folks. In a nutshell, if you want to put it in. If the point is just to get to the document, you can race through that pretty quickly. You can work out, a very abbreviated set of questions that should get you there. Sir, have you been sent here to testify to the records of your company? Yes, I have. Are you familiar with Exhibit 101 that I placed before you? Yes, I am. Have you seen documents like that in the past? I have. Is that document made by your company? Yes, it is. Is it the regular practice of your company to make and keep that document. It is. Is it made at or about the time of the events it describes? It is. Thank you, I move Exhibit 101. That's it. If I really want to motor through it. If crediting the witness or crediting the documents as a matter of foundation is important, then I slow it down and be less formulaic about it. Keeping business records out, that gets messy. I provided an outline just because I thought you should have something for giving you 45 minutes of your life. And I've suggested at least some areas of consideration if you don't want a piece of paper coming in. Those are on the outline. The outline finishes, and I'll finish simply by telling you that there are good evidentiary resources out there and readily available. I gave you my favorites in terms of starting points. And they have different reasons for using them. I mean, Weinstein, which Margaret Berger now is the principal author of, is encyclopedic and oriented toward federal court. Anything that Winkle-Reed writes is encyclopedic and likely to be more oriented toward state court. I like Graham Lilly if you want a 35,000-foot flyover of evidence and someone who's able to write with great clarity, lucidity, about the reasons for our evidentiary rules and to make them fit together coherently. Graham Lilly is terrific at doing that. And among the people out there actively writing on evidence at the law schools, I know of no one who at heart is more a defense lawyer than Paul Gianelli at Case Western. There may be others among widely published evidence authors, but Gianelli is the one I know who's got our sensibility, who just in his gut says sometimes they didn't do it. And even if they did, maybe they ought to get a break. A lot of the folks who write about evidence aren't coming from that perspective at all. So I offer you, Gianelli is someone to consider when you need a look at evidence through defense eyes. I'll let you go. Thank you for listening.
She was a very accomplished assistant state public defender in Wisconsin for a number of years before joining the faculty at UW. She teaches trial advocacy and runs the Defender Project. John Sands has been for a very long time in the Federal Defender's Office in Arizona, and he now runs, and has for the last several years, the Federal Public Defender's Office in Arizona. It's one of the busiest federal public defender offices in the country. Has a large American Indian practice because of the substantial reservations in Arizona, and border crossing practice of drugs, and all of the land fraud and other telemarketing fraud and whatnot that happens out in Phoenix and Tucson and places where folks want to retire and move to. So he is the Federal Public Defender for Arizona, and with his theater background and Michelle's skill, they're going to offer demonstrative evidence.
All right. You ready? First of all, if you remember nothing else about us,
We don't wear suits.
what do we look like? So that when you go home and you say,
That's not what we look like.
it's these two people, I don't remember their names, but they had the Hawaiian shirts, and that would be the point. I would like to introduce you to Frank Ross. Frank Ross was a lawyer in Madison, Wisconsin. He had a tiny little two-person civil firm. refrigerator, and in the middle of winter, that's a season that we have that lasts approximately from October through April, the valve froze open, gas fumes escaped, and the warehouse burnt down. Frank brought a lawsuit on behalf of his client against the manufacturer. The manufacturer brought in experts from all over the country with computerized printouts with algorithms galore to prove that it was impossible for this to happen. Frank did not have a lot of money. His client didn't have a lot of money. But what Frank had was what we sometimes call horse sense. So he rented a duplicate